Charge 4, gang membership. During previous incarceration, you admitted to being a member of the Latin Kings from the time he was young up until 2014 when he denounced his gang membership and/or affiliation. Yet through a search of your phone, you repeatedly and continuously displayed signs, symbols, and/or colors associated with the street gang Latin Kings, as evidenced by tattoos, videos, photographs, social media, and text messages just discovered on your cell phone. As recently as October, pictures of a lion wearing a crown labeled king, black and yellow Pittsburgh Pirates hats, repeated attire and accessories consisting of black and yellow, and hand signs depicted in many of your photographs were sufficient for the Department of Correction to redesignate you as an active member of the security risk group Latin Kings. These repetitive behaviors are in violation of your initial and signed conditions of parole gang affiliation.
Now, we are about to watch the parole revocation hearing of an alleged Latin King member. Now, he's got enough stuff in his jacket to make one be fearful. But there are two items that Holly, our latest researcher, and I'll share more about her in the unpacking, also pointed out that he has a chomo full jacket. He has two convictions, one for what he did to a 15-year-old and one time of what he did to a 10-year-old. And now part of his revocation problems is that he is disappearing night after night after night and finding out that he's spending time at his girlfriend's house, his girlfriend who has young children. Let that sink in. Now with that, let's jump in.
Good morning, P.O. Huff. Are you logged on?
Good morning. Yes, I am.
Perfect. All right. So we're going to get started with the revocation hearing. Good morning. I'm P.O. Meisier, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Maldonado Orlando number 299666. Today is January 6, 2025. This hearing is being conducted via video at the VOPP Central Office in Corcoran Correctional Center. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Orlando Manuel Maldonado 299666.
Thank you. We also have a parole officer present. Can you please identify yourself for the record?
Parole Officer Huff, Hartford Special Management Unit.
Thank you. And we have counsel here today. Please identify yourself.
Yes, Public Defender Robert J. McLetty of the Parole Revocation Unit. Hello, sir.
No.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better leader evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge, state your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today, the right to have an attorney present, and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case at this hearing. You have a right to call and examine voluntary witnesses, cross-examine adverse witnesses. Do you understand these rights? Are you ready to move forward?
Yes, ma'am.
Okay, so we'll now review the charge. The state your appeal is bringing against you and the information underlying each charge. Appeal Huff, will you please read the charges?
Yes, ma'am. Charge 1, GPS. You feel the charge of GPS as directed, resulting in battery violations on 3/12/24, 3/13/24, and 3/15/24. You sign a misconduct acknowledging this behavior on 3/20/24. You failed to go directly home as previously directed due to your late work hours on 5/16/24 and were at an unapproved location from 3:53 a.m. until 5:54 a.m. You sign a misconduct acknowledging this behavior on 6/4/24. You were directed to stay away from your girlfriend's residence located at Nortford due to the presence of minor age children at the residence. You were at the residence for a prolonged period of time on 5/17/24, 5/18/24, 5/19/24, 5/20/24, and 5/21/24. You signed a misconduct acknowledging these behaviors on 6/4/24. You again visited your girlfriend's residence on 7/9/24, 7/11/24, 7/13/24, 7/16/24, and 7/18/24. You signed a misconduct acknowledging these behaviors on 7/23/24. These behaviors are in violation of the GPS monitoring agreement you initialed and signed on 3/5/24. Charge 2, obey all laws, obedience to the law. On October 28, 2024, you physically assaulted your pregnant girlfriend at your parole-sponsored Crystal's apartment. You grabbed her by her hair and pushed her on the floor, and while she's on the floor, you jerked her head back and forth a couple of times while pulling her hair, causing her pain. This caused her to feel endangered and call 911, but hung up because she was still inside of Maldonado's home and she was afraid. These violent behaviors are in violation of Connecticut General Statutes 53A-61A, assault in the third degree on a pregnant person, and 53A-181, breach of peace in the second degree. This assaultive behavior is also in violation of your initial and signed conditions of parole, obey all laws. You're subsequently arrested and arraigned on 10/29/24 when probable cause was established and a bond was set. On December 13th, 2022, while on special parole supervision, you were in possession of a Glock firearm as evidenced by pictures on your cell phone. As a convicted felon and offender with the Deadly Weapons Offender Registry, this repeated behavior is in violation of Connecticut General Statute 53A-217, felon in possession of a firearm or ammunition. A person who is guilty of criminal possession of a firearm, ammunition, or electronic defense weapon when such person possesses a firearm, ammunition, or electronic defense weapon, and one has been convicted of a felony prior to, on, or after October 1st, 2013. Weapons. On January 1st, 2023, while on special parole supervision, you were on video with a firearm and ammunition under your control, instructing a child shooting a firearm. The ammunition on the table and the firearm are in the area and vicinity under your immediate control. The authenticity of the firearm is verified by the presence of an explosion, muzzle flash, and ejection of a shell casing, following each round fired. Your presence is verified through the distinct sound of your voice and the tattoos on your left hand. On December 13th, 2022, you possessed a Glock firearm as evidenced by 2 photographs discovered on your cell phone. These behaviors are in violation of your initial and signed conditions of parole, obey all laws. I will not use or have in my possession or control any firearms, ammunition, or any other weapon. Charge 4, gang membership. During previous incarceration, you admitted to being a member of the Latin Kings from the time he was young up until 2014 when he denounced his gang membership and/or affiliation. Yet through a search of your phone, you repeatedly and continuously displayed signs, symbols, and/or colors associated with the street gang Latin Kings, as evidenced by tattoos, videos, photographs, social media, and text messages discovered on your cell phone. As recently as October 25th, 2024, your Facebook account name, text message received and sent stating ADR, Amodere, pictures of a lion wearing a crown labeled king, black and yellow Pittsburgh Pirates hats, repeated attire and accessories consisting of black and yellow, and hand signs depicted in many of your photographs were sufficient for the Department of Correction to redesignate you as an active member of the security risk group Latin Kings. These repetitive behaviors are in violation of your initial and signed conditions of parole, gang affiliation. Charge 5, halfway house placement. You strayed from your halfway house pass approved destinations and visited locations you were not approved to visit on 3/13/24, 3/14/24, 3/15/24, and 3/18/24. You signed a misconduct acknowledging these behaviors on 3/20/24. Charge 6, no contact with minors. In a cell phone video taken on January 1st, 2023, you had unauthorized contact with a minor at a shooting range. At no point in time did your parole officer grant you permission to have contact with minor-age children. During a review of your cell phone, it was determined that you communicated with your daughter, 15-year-old J. Date of birth 3/2009, via text messaging on 10/24, 10/25, 10/26, and 10/27/24. At no point were you given permission to be in communication with minor-age children. During a review of your cell phone text messages, it was determined that On Saturday, October 26, 2024, you picked up your 15-year-old daughter, Jay Release, from West Hartford Police Department and transported her to your girlfriend's house on Willis Street in Hartford. This was verified by your GPS points and a collect hit from the West Hartford Police Department. At no point did you have permission to be in contact with minor-age children. These behaviors are in violation of your initial and signed conditions of parole, general contact, no contact with minors.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand actual custody order, B, parole violation report, C, notice of parole violation, D, parole and community service defined conditions, E, Hartford Police Department incident report ending in 7935. Exhibit F, GPS monitoring agreement, G, misconduct and evidence, H, CT judicial department pre-sentence investigation report, I, BOPP decision information summary, J, BOPP revocation hearing summary 62623, K, CTDOC SRG affiliation documents, L, cell phone pictures, M, CAPI photo, N, Allied Universal GPS points 102624, OCT DOC visitor status, P, cell phone videos, Q, letter from Glock, R, signed halfway house agreement. Did you receive notice of parole violation report, and those other documents, and did you review them, sir?
Yes, madam.
And council has filed the following exhibit pre-marked for identification purposes as Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Having no witnesses, I'm going to put on the record, I received the addendum from PCS. The addendum reported on 11/27/24. Offender was convicted of breach of peace second and received an unconditional discharge with all other charges nollied. So at this time, the state will have an opportunity to call to speak to any of the evidence submitted at this time. I'm going to swear in both Mr. Maldonado as well as P.O. Huff in an event that you would like to speak. So can you please both raise your right hand? You solemnly swear or honestly affirm, as the case may be, the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth to help you God about penalty of perjury?
Yes, ma'am.
Yes, ma'am.
All right, so P.O. Huff, at this time, would you like to say anything in regards to the charges?
I'm sure. I just want to touch base on the fact that Mr. Maldonado's instant offense back in 2016, he was convicted of illegal sexual contact with a minor, burglary, assault third, and criminal possession of a firearm. He was last remanded to custody on April 13, 2023 for committing a burglary in Windsor Locks. He was sentenced to 1 year by the court. He was released about 11 months later to the halfway house back in March 2024. And just under 8 months later, he was again arrested for similar charges anyways with assault third and breach of peace. And then the discovery of the firearms and him possessing firearms and being around firearms on his phone show that he has not strayed far from his behavior back from his original offense back in 2016. And although he did receive an unconditional discharge and the assault third charge was nollied, it does not negate the behavior.
Thank you.
Yep.
So at this time, defense will have an opportunity to speak at this time.
Yes, just to clarify things, he was released on 3/5/24 to parole, correct?
I'm sorry, say that again, sir?
He was re-released to parole on 3/5/24, correct?
Yes, sir.
Okay, thank you. So I would contend that any of the conduct that occurred prior to 3/5/24 should not be part of this violation, which would include in charge 2, part B, which would be conduct from December 13th of 2022. So I don't believe that there's sufficient evidence and this should not be covered in this violation. That would be part 1 and part 2 of charge 3 weapons from January 1st, 2023, since he wasn't released until March of 2024, December 13th, 2022. Also, no contact with minors. That cell phone video was taken on January 1st, 2023, allegedly, and all the conduct in charge 6. So I don't believe under the preponderance of the evidence standard, and I certainly don't believe under the rules of evidence, and that none of this conduct occurred since its release on 3/5/24. As to charge 1, I have no comment regarding the GPS violations regarding the preponderance standard. As to charge 2, he was not convicted of any assault of conduct whatsoever. He received an unconditional discharge for breach of peace. Part B of that occurred in 2022. Even if so, even if allegedly Exhibit Q says that it matches the serial numbers and looks like a Glock, smells like a Glock, we do not know because we don't know whether or not under the definition of firearms that was capable of firing a shot back in 2022, which was before this period of supervision. Also, the conduct from 1/1/23 and 12/13/22 from charge 3 should not be considered merely because he was possessing a Glock in a photo. We don't know if it was a Glock. We don't know if it was a firearm. We don't know if it was capable of firing a shot. As to charge 4, gang membership, who, what, when, where, how was that information posted? Was a search of his phone? We don't know merely because of the coincidence that he in the past, it's uncontroverted that he was in the past a Latin King. We don't know when those were placed on there. We don't know how those were placed on there. I don't believe there's significant foundation to prove charge 4. I don't believe it meets the preponderance standard. Thank you.
Thank you.
I just have a few comments when we get them.
Go ahead.
In regards to the nollie just means I'm not willing to prosecute, does not excuse the behavior. It's not a not guilty charge by any means. The sex offender registry designation, actually not, the security risk group designation was enough for DOC to feel confident enough and sufficient to place him in the SRG program that he's currently in that right now. In regards to the charges that he was on previous, he was still under special parole supervision when these firearms were discovered. Not when they were discovered, but when he was still on special parole supervision, regardless if he was charged with it or not. We were not aware of the behavior at the time, so he was not charged until we became aware of the behavior. So it does not excuse the fact that he's in possession of these items while he is on special parole supervision. Let's see. And also, I have some privileged information. I was talking to the Special Licensing and Firearms Unit with the state
I would
police.
object to any privileged information that I haven't been apprised of prior to this hearing.
Well, if he's going to notify us both now, I mean, what?
I know it across. Okay, fine.
Who's it from?
Through the Detective Warrenda from the Special Licensing and Firearms Unit.
I would object as hearsay.
Well, hearsay is acceptable. Go ahead.
This says that in regards to the firearm that he is possessing, this firearm has what appears to be a functioning slide lock, the gap between the bottom along the slide lock to be pulled down. The officially licensed Glock BB guns seem to have a slide lock that is solid plastic. This firearm has what appears to be a functioning trigger pin since it is set into the firearm. Officially licensed Glock BB guns seem to have raised circles mimicking a trigger pin. So this in conjunction with the letter from Glock is verifying that these are in fact real firearms, and the one that is taken on somebody's lap, and the one him holding his hand in his hand, has a unique hand grip on it, which would determine that those two are the ones that Glock had certified as a real firearm, and the one him possessing in his hand would lead a reasonable person to believe that is the same firearm due to the unique hand grip that was on it.
Just briefly, we don't know if those are functional firearms. We don't know if they meet the definition of firearm. We don't know if they're capable of firing a shot. We don't know if they're real. They can look real. They will not be real. Thank you.
And we can always look back at that video as well, which kind of speaks for itself. And the Glock and the detectives for the Special Licensing and Firearms Unit are more experts in this category than I think any of us would be.
Thank you. All right, so I'll be right with you with my findings. All right, so regarding charge 1, I do find that you violate that condition release section GPS based on evidence that was provided in support of the charge D, F, and G. And I do want to note that you have been on supervision since 12/18 of 2019, so all of these charges do apply as you were on special parole supervision at the time of all these instances. On charge 2, I do find you violated condition, obey all laws, obedience to the law. Part 1, based on your conviction or breach of P2, received a sentence of unconditional discharge. All other charges nollied. Part 2, I do make a finding based on evidence that was presented by the state, which is exhibits D, L, and Q. On charge 3, I find you violated condition weapons based on evidence provided in support of the charge, which is exhibits D and P on part 1 and D and L and Q on part 2. On charge 4, I find you violate condition, gang affiliation, gangs membership based on the evidence that was provided, exhibits K, L, M, D. On charge 5, I do find you violate condition, halfway house placement based on the evidence that was provided, exhibits D, G, and R. On charge 6, I find you violate condition, no contact with minors based on evidence provided, which is exhibits D, O, L, P, and N. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So P.O. Huff, do you have anything you'd like to say in regards to the second part of the hearing?
Not particularly, just saying this is he's exhibiting the similar behaviors that he was originally convicted of back in 2016. And if I could, I would just like to add a no contact with the victim in regards to this most recent assault case, please.
My counsel did say anything?
Yes. My client is single, 42 years of age. She received support from his mother, father, 3 brothers, and 5 sisters. He obtained his GED in 2003. He had worked in the past at the Home Depot Distribution Center. He worked full-time at Valvoline for 5 months. He had participated in outpatient services at CRT briefly. He also was medication compliant. He wishes to be placed in a halfway house in Hartford, wishes to enroll in Lincoln Technical Institution in auto mechanics, return to his full-time position at Valvoline on Silas Dean Highway in Wethersfield. I don't think a lengthy sanction is appropriate here. I know the PO recommended a 12-month sanction. We would ask for a lower sanction than that. Thank you for your time and consideration.
Thank you. All right, so I've listened to testimony. I have reviewed all the evidence that was presented. I'm going to put on the record, you were out there about 7 months and 24 days before you returned to custody on new charges that do mirror previous offenses you are on special parole for. You did receive the new sentence as well, have a prior violation that is also criminal in nature, and which you received a 1-year sentence for that. You did receive 5 misconducts on this period of supervision, were redesignated as a Latin King, and do have a history of weapon possession and violence. Based on all the information, as well as everything that was presented at today's hearing, and I will note your officer recommended a year incarceration after dispo of charges. So I'm going to recommend that parole be revoked. You be re-paroled for November 28th of 2025, which is about a year and a month period of confinement as a sanction. I also recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, behavior management program for domestic violence, no contact with your co-defendant, Wilfredo Fernandez, number 381011, no contact with your victim, YRM, DR, and JG, enhanced internet and device monitoring, a general no contact with 30 Connecticut, Albert Seattle, without PO's permission, mental health evaluation and treatment as deemed necessary, no contact with minors without PO's permission, problem sexual behavior treatment, and restriction on pornography. My findings, recommendations are going to the parole board January 16th. So the board's going to make the final decision. This is just a recommendation. So the board does have the ability to revoke all of special parole. I'm trying to give you time to participate in the SRG programming in the facility before you are re-released back out into the community. So that's why I'm trying to release you back out on relatively, just giving you enough time in the facility to participate. Do you have any questions about anything that was said?
Oh, man.
All right, so you're all set for today. The board will notify you about a week after in writing, or you can speak to your attorney on January 16th or the next day after.
Give me a call on the 17th of January, sir, and I'll tell you what the board decided. Okay, sir?
Yes, ma'am. Yes, sir. Thank you.
So just 1 year. 1 year is what they decide they should give this repeat child chomo offender who is disappearing night after night after night, ending up at his girlfriend's house where there are children there. And now, why is that dangerous? It's because he has two convictions against children. One against a 15-year-old, which happened in 2007, and one against a 10-year-old, which happened, when was that? In 2016? And he only served 3 years for that one, a 10-year-old. And he's out on parole, and he's gone night after night after night with his girlfriend and her little kids. And you just have to say, do we not care about our children? He's not just a gang member or alleged gang member. I don't even know what the conclusion was on that. He found him guilty of the gang affiliation. It's like, but he's a chomo. I didn't know Latin Kings allowed chomos in their organization. I don't know much about gangs, but I don't know. I just did it, I guess. What do I know? 1 year. 1 year. And you know what this is? I'm starting to understand this slowly. I'm starting to do a little bit of research on more independent research on these things. Like I have an AI bot that I guess that I've gone down the rabbit hole with. And I asked my AI, I said, where does Connecticut fall out on per capita incarceration rates? Because we all know that Louisiana is like known as the worst or second to worst with per capita incarceration. And everybody looks down at Louisiana and they are a backward state and they lock everybody up. And then you ask about Connecticut and they say, Connecticut is one of the lowest per capita incarceration rates. And they say that the reason for this is because of their progressive approach to rehabilitation. And that's when I was like, my aha moment. It's all, I'll use the word again, a gimmick. It's a manipulation of the system. You see, in Connecticut, it's not like crime is any less. It's just that they get smaller sentences. And then the way they set it up where you get special parole. So you offend against a 10-year-old as your second time being a chomo, being a gang member, having a long rap sheet. He has many offenses in his jacket, as I'm sure you can imagine. But then you get out after 3 years. And then you get revoked. And when you get revoked and you have to serve a year time, that falls under different numbers in the bracket. They don't include that as their per capita rap sheet. You see, it's not even a new felony. It's just a violation of his parole. And then what they do is that you'll have the governors, you'll have the people who are getting paid, you'll have whatever it is, all the people that are benefiting by saying the progressive approach is what's making Connecticut lead the path as a what's the word I'm looking for? A trailblazer in proper incarceration, but yet it's not true. All it's doing is creating more victims, but yet they get to brag about their progressive approach and how it's making a difference, and it's all a lie. They're all gaslighting us. And this is it. We've seen it right here. And I'm starting to figure this all out, and it's pretty crazy. Because again, when you take a step back and you hear Connecticut brag about how they have a lower per capita incarceration rate and their progressive approach is why, and all it comes down to is that they give fewer year sentencing, and they don't count a revocation as being locked up or as a new crime. Look, it's messed up. I think this is just, it's really messed up. I hope people will see through this one day. I hope this can help get those things through. And now finally, I want to give a special thank you to Holly, who goes by the YouTube handle of Great Dane. She's from Australia. She's been doing research consistently enough where I feel now comfortable to say she's the real deal. I'm reading from the research on this case that Holly put in. Sir Richard's been working with Holly to get her up to speed, to get her into all the research, and she's doing an outstanding job. And of course she is. She was a military career, an officer in the Air Force. She's comfortable with reports, of course. This is easy for it, and she's just doing a stellar job. And we thank her for her service. She was a tour in Afghanistan, and my understanding was disabled while serving in Afghanistan. So I haven't gotten all the details or any details of that. Just I know that it happened. So maybe one day Holly will share her story with us. But thank you, Holly, for doing all of this research. And helping, because Sir Richard, his eyesight, it's really going on us. And there are so many, we cover, I don't know how many hundreds of cases a week that we need to do research on. So this is quite amazing. Now, anyways, he's going to get out in a year, and I'm sure we'll see more of him. And it's just great. Like, it just blows my mind. When you look through the information Holly shared on this, in 2013, he has criminal possession of a firearm. 5 months later, October 2013, he has illegal sexual contact with the, what was that, the 10-year-old. He has burglary in 2016, assault 3rd degree in 2016. He has the sexual charge in 15? Then he has the October 28th, 2024 breach of peace. And it's just nonstop. And that's Connecticut only shares the past 10 years with us. Otherwise, I'm sure there's more. But his attorney, Mananagladi.
Everybody has a terrible time trying to pronounce his name. How do you spell that again? I'm like family and Getty. Family and Getty.
Helpful. Family.
Right.
Absolutely. Go ahead, attorney.
And
Yeah, whatever his name is, he did his thing. What can you say? With that, I'll let you go.
You were directed to stay away from your girlfriend's residence located at Nortford due to the presence of minor age children at the residence. You were at the residence for a prolonged period of time on 5/17/24, 5/18/24, 5/19/24, 5/20/24, and 5/21/24.